There was a precursor to the Voting Rights Act. It was called the Federal Elections Bill of 1890. It was designed to do many of the same things that the Voting Rights Act eventually did.
It would have applied nationwide, and it would have provided federal oversight of elections from registration to casting a ballot. It would have had the effect of addressing fraud in voting. It would have had the effect of also addressing the disenfranchisement of African Americans, because it would have limited the discretion that Southern registrars had to disenfranchise that population.
And it failed very, very narrowly in Congress. Really, a few votes on a filibuster would have made the difference.
So the Federal Elections Bill, also known as the Lodge Force Act, probably would have resulted in more people voting. So we wouldn't have needed a 1965 Voting Rights Act.
When I was growing up, I saw the need for change. And the action of Rosa Parks and the words and leadership of Dr. King inspired me to try to do something about it. So through the Civil Rights Movement and later the whole push for the right to vote became part of my involvement. I happen to believe that the right to vote is precious. It's almost sacred in a democratic society such as ours. It is the most powerful, non-violent instrument or tool that we have. And everybody, every single person who's a citizen, who's of age, should be able to cast that vote. It should be as simple, as easy as getting a glass of water. And there must not be anything to prohibit or infringe on that right. During the 60s, my mother, my father, my grandparents, and so many of my teachers couldn't register to vote simply because of the color of their skin. There were people told they could not read or write well enough, that to pass a so-called literacy test, interpret certain section of the Constitution of the state of Alabama, or count the number of bubbles in a bar of soap, the number of jelly beans in a jar. So we organized, we mobilized. We did what I call getting in the way. During the summer of 1964, we organized the Mississippi Summer Project for more than 1,000 young people, students, religious leaders, lawyers and doctors and teachers came south. And I will never forget, on the summer night of June 21st, 1964, 3 young men that I knew, Andy Goodman and Mickey Scherner from New York, and James Shaney from the state of Mississippi, went out to investigate the burning of an African-American church to be used for voter registration workshop. These 3 young men were detained by the sheriff, arrested, and later that evening they were taken from the jail and turned over to the Klan, where they were beaten, shot, and killed. It was a sad and dark time for the movement, but we didn't give up. We kept the faith. We kept our eyes on the prize. We kept working, and we kept pushing. On Sunday, March 7, 1965, about 600 of us attempted to walk or march from Selma to Montgomery to dramatize to the nation and to the world that people wanted to register to vote, to become participants in the democratic process. We had a right to march, the right to protest. The right to assembly is guaranteed and protected by the Constitution. But on that day, we were beaten, we were trampled by horses, we were tear gassed. I was hit in the head by a state trooper, had a concussion at the bridge. I thought I saw death. I thought I was going to die. But somehow, in some way, people responded to the fact that these American citizens were so determined, that the President of the United States responded, the Congress responded. And President Lyndon Johnson introduced the Voting Rights Act. Congress debated it, it passed, and it was signed into law on August 6, 1965. Only thing I did, I gave a little blood on that bridge. But others throughout the South gave their very lives.
The Voting Rights Act was the most successful civil rights law probably in American history. It ended discrimination in voting. It enabled African Americans, people who didn't speak English so well, all kinds of racial minorities, to be able to actually exercise the franchise.
We often think about the Voting Rights Act in connection with African American suffrage, but it was also very important for women because it helped to manifest the promise and the ideals of these earlier amendments, 14th Amendment, 15th Amendment, and the 19th.
The reason for the Voting Rights Act of 1965 was the difficulty of enforcing the rules already in place prohibiting bias in running elections. What it said is for those districts that were the most egregious at excluding people from the vote, essentially where you had under 50% voter registration of people based on race, as of the end of 1964.
The most important provisions of the Voting Rights Act, Section 2 prohibited any abridgment or denial of the right to vote on the basis of race, and it applied nationwide. Section 5 of the Voting Rights Act applied to most states in the Deep South and some other jurisdictions, and basically it required those jurisdictions to pre-clear any changes to their election laws.
If you want to change your voting regulations, rules, times, machines, anything, you had to go to the government first, the Justice Department or a 3-judge court of the District of Columbia, and simply say, here's our plan. And they then had 90 days to look at it and say, one thing, would this make it harder for minorities to vote? If the answer was yes, it would make it harder, they would deny it. If they wouldn't make it harder, didn't have to make it easier, but if it didn't make it harder, they would allow it to go through.
The Voting Rights Act, Section 5 in particular, has been reauthorized several times. And the interesting thing is that every time that it's reauthorized, it's challenged as unconstitutional. So Shelby County is in Alabama, and that is a state that has had a terrible record on voting rights. So Shelby County versus Holder became a case because the government under Eric Holder refused to pre-clear a change that they wanted to make to their law, and they challenged the constitutionality of the Voting Rights Act.
In the Shelby County case in 2013, the Supreme Court effectively gutted Section 5 of the Voting Rights Act.
This was a provision of the Voting Rights Act that has been credited for much of the social gains that we've had in this country and has been attributed to much of the opening up of the electoral process that we've seen, and has also been upheld by numerous Supreme Courts before it.
In the 5-4 decision, the Supreme Court found that the coverage formula of the Voting Rights Act was unconstitutional because it had the effect of discriminating between the states in what the Chief Justice termed the equal sovereignty principle. So it treated states in the South worse than it treated northern states that had committed similar voting rights violations, but were not subject to the preclearance requirement. So he said that was a violation of our Constitution's principle of equal sovereignty. So equal sovereignty has typically referred to the conditions upon which states are admitted to the Union. We have not viewed it as a principle that applies for the duration of the life of a state. So the Chief Justice, I think, applied the equal sovereignty principle in a very novel way.
This Supreme Court decided that the particular provision that said where Section 5 had to operate, it's also called the Section 4, was outdated. And that because it was outdated, Section 5 couldn't operate anywhere, which was a tremendous blow. being dealt to the effectiveness of the Voting Rights Act, and also means that parts of the country that had enjoyed federal protection against race discrimination lost some of the strongest federal protections that they had.
Section 5 had largely succeeded in its fundamental purposes, so it became less and less important over time. Now that you had black political power, it became harder and harder to say that the only way that blacks could exercise political power is if they were protected by the federal government.
After the Shelby County decision came down, we saw Texas try to immediately begin operating the most restrictive photo ID law in the country. We saw politicians in North Carolina say publicly that now that there's not Section 5, they're going to add more to a bill that would have made it harder for people to vote. Places that had had restrictive policies in abeyance because they knew that they wouldn't pass Section 5 muster suddenly opened the floodgates.
There's no question that states felt liberated by this, but I don't know that it made that much difference politically. And I don't know that Section 5 did anything but say that Texas would have done that anyway and would have litigated it in D.C. District Court. Instead, they litigated it in Texas District Court. They would have had, hopefully, an unwelcome reception in D.C. District Court. They certainly got an unwelcome reception in Texas District Court.
When the Supreme Court made a decision gutting the Voting Rights Act of 1965, I wanted to cry. I would love to take members of the United States Supreme Court back to Selma and walk across that bridge.
I really believe that voting is the key to addressing every one of our social, economic problems that we face as a people.
The more people who participate, the better it is for democracy.
We are not a democracy for the most of us, we are a democracy for all of us.
I think most politicians worry about are whether or not they're going to be reelected. And by getting out there and voting, you make that determination.
I think young people can make such a big difference, and so many of us have strong opinions, and we go out and we protest, so much of us, but so few of us make the decision to go out there and vote. But the moment that we make that decision to step into a voting booth, that's when we can really change our elected officials, and that's when we can really get the policies that we want in place.
We're still trying to figure out all of the fallout from having a court that does not think that the Voting Rights Act is needed, a court that does not think partisan gerrymandering is a threat to our democracy. We are still trying to figure out what that means for the future of the right to vote, and it's a conversation that we'll be having for decades to come.
You cannot ask them to hear you if you are not talking. Go vote, go out there, make sure that what you're saying is being heard. There's no reason not to.
There's no such thing as not voting. Not voting is voting. It's voting to turn your power over to somebody who might have a completely opposed view of what should happen.
Your power is you decide who decides.